In Hennepin County, Minnesota, former officer Kim Potter on trial for manslaughter after shooting and killing Dante Wright during a traffic stop. Testimony continuing in the prosecution's case as the jury tries to figure out if the shooting was an accident, a crime, or a justified use of deadly force. We are live with the latest.
New motions from the prosecution hope to undercut the testimony of one of their own witnesses. Former Brooklyn Center police officer Michael Johnson told the jury that Kim Potter would have been justified in using deadly force in the shooting of Dante Wright. Now the prosecution wants that stricken from the record. We'll tell you how they plan to do it coming up.
In Pontiac, Michigan, the accused Oxford school shooter is locked up in jail, but his attorneys think he should get out of jail and be held in juvenile detention.
His conduct could be a menace to other juveniles. I think his placement is appropriate in the adult facility, specifically the Oakland County Jail.
In Delphi, Indiana, reaction tonight from the grandfather of teenager Libby German, who was murdered along with her friend Abby Williams back in 2017. This as the state police release new information about a child pornographer. Is he connected to the murders?
There's predators out there that are preying upon our children.
On the docket tonight in Statesboro, Georgia, Marcus Wilson accused of shooting and killing a 17-year-old girl while driving down the highway. Wilson claims self-defense. We take a closer look.
He felt like his life was threatened, and I 100% believe that.
In tonight's Unsolved Case File in Chesterfield, Virginia, young father Damian West was working security at an apartment complex when he was murdered at the end of his shift. It's been more than 12 years and still no justice for Damian's mom.
Somebody's gonna pay for what they did for my son, and I mean that. They're gonna pay for that.
Was Kim Potter's use of deadly force against Dante Wright justified? Was her fellow officer in danger of great bodily harm or death? We take a look with our own law enforcement experts. And in Philadelphia, Pennsylvania, a man robs a hotel and is caught on camera doing it. We break down the video during crime time. Plus, Ghislaine Maxwell's attorneys have spent a lot of time trying to separate Maxwell from billionaire sex offender Jeffrey Epstein. But photos show the couple seem to be very close and intimate. Tonight's 13th juror question: what exactly was the nature of the relationship between Ghislaine Maxwell and Jeffrey Epstein? Go to our Facebook pages and let us know. Buckle your seatbelts. This hour of closing arguments starts right now. I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. From where I'm sitting, the prosecution is scrambling right now. Absolutely scrambling in the case against Kim Potter. All because of what happened last week, which was their own witness getting up on the witness stand and saying that Kim Potter was justified in using deadly force. Now, that's not even the primary defense to this case, but it is powerful, it's important, and if the jury believes that, it's over. It's absolutely over. So what are you supposed to do as a prosecutor? Well, they're trying to get that testimony stricken. Now, we're going to talk about that in just a little bit with Chanley Painter. But think about what they're trying to do is get rid of the testimony of one of their own witnesses that they called to the stand. How does that look in front of the jury? If you, as the prosecutor, again, I say this all the time, your job as the prosecutor is to seek justice, which is the truth, okay? So you're going to now try to tell this jury, don't listen to what my witnesses were saying? And it may be objectionable, and legally maybe the jury shouldn't have heard it, but they did. Are you going to argue that your witness was lying? I don't know. I mean, they're absolutely in scramble mode at this point. Now, another way that they can try to respond to all this, again, it's Officer Michael Johnson. He was a sergeant at the time. Now he works for the Sheriff's Department. He's a major. Was talking about what happened at that moment. He's on the other side of the car. He's the one who's leaning in. He's the one trying to make sure that Dante Wright doesn't take off. And the question is, if Dante Wright gets control of the car, is now Sergeant Johnson in danger of great bodily harm or potentially death? He said yes. And he said, as a result, under Minnesota statutes, you're allowed to use the type of force, deadly force, that Kim Potter used. So another way that prosecutors are trying to attack this, I guess, is to attack whether or not he was actually in danger, whether or not there actually was that potential threat to his life or threat of great bodily injury. And now you're talking about splitting seconds in what was transpiring inside the car. As Johnson is in on one side and Kim Potter and Lucky are on the other side, and Kim Potter is yelling, taser, taser, taser. Is Johnson still in the car? Is he out of the car? And what prosecutors want to do is get Johnson out of the car. You get him out of the car, and now all of a sudden, no longer is he at the risk of death or great bodily injury. And then all of a sudden, deadly force is not justified. And now we get back to square one of the trial, which is, okay, this is an accident. Is it so egregious that it's a crime? But you don't even get to that part of the analysis if this is a justified use of force. So let's take a look at what happened today. Brent Peterson, BCI Special Agent, Bureau of Criminal Investigation, again, called by prosecutors, and prosecutors now trying to get into, is he in, is he out, is he in danger, is he not in danger? Take a listen.
Okay, you'd agree the video is now paused at 2:02 and 0 seconds, correct?
Correct.
Can you see where Officer Lucky's body is at this time?
From this video, the bottom video there from the squad camera, it appears that his feet and legs are outside the vehicle on the pavement, and his torso is kind of leaning towards the open door.
If you look at the top left corner in Officer Potter's body on camera, are Officer Lucky's shoulders inside the vehicle or outside the vehicle?
Based on the view of this video, it does not appear that his shoulders are in the vehicle.
Okay. Did you also examine Sergeant Johnson's position at various points during this incident?
Your Honor, I object to this. The video speaks for itself. The time speaks for itself. This officer's view of it should not be, the jury's the one that decides. It's not this officer. He's not an expert of videos.
All right. Counsel, will you please?
You'll recall in Derek Chauvin's trial, we had sort of the same thing. We had different witnesses describing the video that we've all seen, saying what they saw. Well, here, the defense objecting to that. Time to hear from the judge.
Counsel, let's talk about what we're doing from here on out with this witness. I am not going to allow BCA agents to get up on the stand and tell the jury what a video shows. The video is the evidence, especially when it comes through the mouth of a BCA agent. You know, the jury may get the impression that this person is an expert at looking at video. The jury's going to have that video. They can look at it as much as they want in the jury deliberation room. The state has the right to argue that Officer Johnson wasn't in danger of getting dragged by the car in final argument. That's totally fair game. You know, the state can argue and stop the video in final argument and say, look, both of his feet are on the ground. That's all fair game, but I'm not going to let the witnesses tell the jury what's on there. Okay?
All right, you heard the judge. The video speaks for itself. So now let's take a look at the video. And this is actually 3 different perspectives all at once. At the moment of the shooting, one of those perspectives will freeze because we don't show that on television. here on Court TV, but you'll see the rest of the videos continue. So let's take a look for yourself. Here it is, the actual video that the jury will have to decide. Was he in danger or out of danger at the moment that the gun was fired?
Just stay back. I'll tease you! Taser, taser, taser! Ah, he shot me. I just shot him. Dead? Yes!
Jury will have to figure it out. Let's bring in Court TV legal correspondent Chanley Painter, joining us live tonight from Minneapolis. Chanley, this is really a huge issue now in this case, not an issue that I anticipated being a part of this trial. Now it is the focus of this trial. Tell us a little bit more, though, about what Sergeant Johnson said, because he testified on Friday about all of this, and he is the person that we're talking about here.
Yeah, this is a huge witness for the prosecution because he's there at the scene. But on cross-examination, like you said, Vinny, the defense really able to score some major wins that go to its theory of the case, that if Kim Potter even intended to use deadly force under those circumstances, it would have been authorized and justified given what her co-workers, her colleagues there at the scene said. Not only did Michael Johnson, the former Brooklyn Center police supervisor, but also Lucky, her trainee that day, also corroborated that testimony on day one of this trial that he would have also used a taser, that his life was also in danger had Daunte Wright been able to flee without force being used. But let's take a listen back to Friday when Michael Johnson told this jury on cross-examination that he felt that this was appropriate use of force.
She said, oh my God, I'm going to go to prison. Do you remember her saying that?
Yes.
And Lucky said, according to the video, no, you're not. No, you're not. Kimberly says again, oh my God. Lucky says again, no, you're not. You remember that?
I don't.
All right. Then you said, Kim, the guy that was trying to take off with me in the car. You agree you said that, right?
Yes.
And if he had taken off with you in that car halfway, what would have happened to you? What would you think would be the worst that would happen?
Probably dragged.
Dragged and what?
Injured.
Seriously injured, maybe even dead, right?
Yes.
And if that were the case, would an officer in your position, with Officer Potter trying to stop him from resisting with you and resisting Lucky, would it be fair for that officer to use a firearm to stop him?
By state statute, yes.
By state statute.
Yes.
There's a statute that says to avoid death or grave bodily harm, you have a right to use deadly force, correct?
Yes.
And you're aware of that statute?
Yes.
This examination went on, Vinny, for this Officer Johnson to say, yes, a vehicle can be considered a deadly weapon, and force meeting force with deadly force with deadly force. That's what the defense wanted this jury to hear. Now, the prosecution tried to rehabilitate Johnson, of course, Vinny, with saying, you didn't tase Daunte Wright, you didn't use your firearm, you actually weren't drugged in the vehicle when it did, in fact, take off. But ultimately, the takeaways there are some major points for this defense.
Major points. I posted a video on social media talking about how different this is than the Derek Chauvin trial, where no member of law enforcement was coming forward saying that was proper, what Derek Chauvin did. I mean, it was tough. I couldn't even get a guest on the show to talk about that. This is a much different situation where you've got the officer at the scene saying, yeah, this was proper use of force. So now the state fighting back. They filed some papers, some motions, trying to get the jury to disregard all of this?
Right. If you notice in the sound you played, there weren't any objections lodged at that moment by the prosecution for a witness, a layperson witness, not someone offered by the state as an expert. He was an eyewitness at the scene. He was able to reach these conclusions about the use of force. So today the prosecution filed a motion to preclude layperson opinion testimony from this trial, Vinny. Here's a look at part of that motion. It says on December 10th, 2021, defendant elicited testimony that her conduct was authorized, quote, by statute. This is precisely the type of factual question that is exclusively within the jury's domain, as the jury will have to determine whether the defendant was authorized to use deadly force. This motion asks for some relief, Benny. They want Officer Johnson's testimony about that stricken from the record. They want Judge Chu to preclude any more witnesses from testifying about this ultimate conclusion that they think the jury is the one to decide whether or not Kim Potter's actions were reasonable that day. And they want some sort of curative instruction, or the judge to read some sort of instruction to the jury to disregard Johnson's testimony and how to handle that as they go back and deliberate.
Unbelievable developments. Unbelievable. All right, Chanley Painter, we'll get back to you in just a little bit. Let's bring in our think tank. Joining us tonight in Tampa, Florida, criminal defense attorney Teresa Jean-Pierre Coy. In Marietta, Georgia, civil attorney, former police officer Lance LaRusso, and also in Atlanta, Georgia, criminal defense attorney Michael Bixon. Welcome to you all. Teresa, your thoughts. Is the prosecution scrambling? Is this game over if the jury believes the prosecution's own witness?
If the jury believes the prosecution's witness, it is game over. And, it's still, it was crazy. My first thought was, were there depositions taken of this officer to get its ultimate conclusions on this? Because how was he able to even come out and say that? It was just really interesting to me. But I definitely think the prosecution is scrambling and they need to figure something out. I don't think the judge is going to issue a curative instruction or, let them do whatever it is that they're trying to do. I don't believe the judge would do that. It was their witness and he testified, and they just going to have to deal with the testimony that came out at trial.
Yeah, Lance, this is kind of like an awkward situation for prosecutors, right? Don't listen to the witness, the eyewitness who we put on the witness stand. They weren't objecting when it was all happening, and now you're trying to, even if you get this jury to disregard it, I mean, what are they going to think? The jury's like, well, the prosecution doesn't want us to consider the evidence that they're presenting in their own case?
Well, listen to everything else he said, but not this little thing that he said. That's the problem they're stuck in. There's two other issues here that people are overlooking. If Kim Potter was justified in using deadly force, then she was justified in using less than deadly force. And if Dante Wright was driving off with a law enforcement officer in his car, he's committing a kidnapping. And at that point, an officer can use deadly force or non-deadly force to stop that forcible felony. Now, if you look at the officer who was on the passenger side, his elbow misses getting caught in the door frame of that car when Dante Wright drives off by a couple of inches. So this idea that they're going to make a distinction between the officer being in danger and not being in danger is like stepping off a gangplank into a moat of alligators. They're in trouble.
Michael Bixon, the whole thing surrounding this issue, it surprised me because I thought this entire trial was going to be about Officer Potter made a mistake. Is the mistake a crime or is it not a crime? What level is this mistake? How egregious is it? And now we're talking about a much more traditional potential part of the defense, which is justified use of force, even though she didn't mean to use it.
Absolutely. And, I usually don't like to have competing theories in a defense case. I like to have one theory and stick to it. But in this case, now that it's come out from the prosecution's own witness, I absolutely would bring it up in closing. And I don't think that the judge is going to, issue any type of limiting instruction. I think that time has come and gone. And for the jurors, I think as well. I think that, they listened to the testimony. And I really do think that they're going to take it into consideration when they're making their decision. But for the defense, I think it's great for them because it does provide an extra avenue to get out of this. And, based on the testimony you heard, I think it's pretty credible.
All right, we're going to talk more about this throughout the show. Our think tank staying with us the whole hour. When we come back, though, a hearing today for the accused Oxford school shooter. We'll show you what happened and what the attorneys were asking for. Like, they want this accused mass murderer out of jail. We'll show you what the judge had to say after this.
The court rule that is being addressed is MCR 6.909, which is the place of confinement for the juveniles, and allows the court for a juvenile confined in a jail or similar facility designed and used to incarcerate adult prisoners upon a showing that the juvenile's habits or conduct are considered a menace to other juveniles. While I did make a ruling prior, I still feel strongly about that his conduct could be a menace to other juveniles. I think his placement is appropriate in the adult facility, specifically the Oakland County Jail. And he, of course, shall be confined and meet the statutory guidelines when the juvenile is in that facility.
Of course, talking about the accused Oxford school shooter, just 15 years old. And this is a problem we have in our system all the time, right? You've got people who are under the age of 18 who are committing horrific or accused of horrific crimes. What do you do with them? Where do you put them? So today, his defense trying to get him out of the adult jail and put into juvie. Let's listen to the arguments.
Your Honor, I don't know whether this is the appropriate time or you would prefer a motion. I do have concerns that his confinement at the Oakland County Jail and pursuant to MCL 764.27A, I'm not sure that he is fully away from the sounds of the adult inmates. And pursuant to the court rule, basically 6.909, there really has to be an assessment that he is either considered a menace to other juveniles or may not otherwise be safely detained in a juvenile facility. I understand the severity of what occurred. I think everybody does, including Mr. Crumbley. But I don't know that simply, indicating that because the victims were of his age, that he would necessarily be a menace. So I do have concerns for him and his mental and emotional well-being. If I have to look out for what his best interest, it's not being at the jail. I believe his needs can be met at the village. At least he will have greater human contact. He will have more services available to him to help him through this. I just feel that it is truly in his best interest, and I don't know that he really meets the standard of the court rule and the statute. And I know that, his charge is not unique in the sense that there have been other children housed at the village with these type of offenses and being charged as an adult. I just feel that I'm not being humorous when I say this, but he could still at least be in school. I mean, there are things, he is still 15 years of age. And there are certain things, many things he's not going to get at the jail. And so I'm imploring you on behalf of him and what's in his best interest that we allow him to go back to the village. I'm not aware for the brief time that he was there he caused any difficulty. I just think for his age, his mental, physical, emotional well-being, housing him at the village would serve him more than where he currently is.
Judge, this cannot be compared to any other case that this court or any court in this county has seen before. And calling this an isolated incident, quite frankly, does not do it justice. This was a mass murder at a school, Judge. This was planned. It was premeditated. The evidence that we have that we discussed at the arraignment showed it was premeditated for a period of time before it was commenced. The defendant didn't just attack other individuals. He targeted juveniles. This defendant fits MCR 6.909 to the T. This court has already made a ruling that the presumption is great that the juvenile committed the offense. and the juveniles charged with first-degree murder. This court already made the ruling that this court could move the defendant from Children's Village to the Oakland County Jail. This defendant is monitored every 15 minutes. His food intake is monitored. His weight is monitored. He has access to mental health care should he choose. He has access to medical care should he choose. If counsel is prepared to put such facts on the record regarding the Oakland County Jail's inability to house this defendant, I would ask for a written motion, and I would also ask this court to review in camera the Oxford High School video that does in fact prove beyond any doubt that this defendant is the individual who perpetrated this offense on other children, Judge. Children's Village is not a secure facility. They have had escapes in the past, in the recent past. I can't imagine a situation where we could put this defendant in a school environment after what he did on November the 30th, Judge.
She actually did ask him to be put in this children's village because he could be in school. That was part of the argument. She knew it when it was coming out of her mouth. It didn't sound right. Let's bring back in our think tank. Michael Bixon, 15 years old, presumed innocent. Strong evidence, according to the prosecutor, including a video of him doing it. Is our system equipped for the 15-year-old mass murderer?
I think it is. I mean, by no means whatsoever is it a perfect system, and I think this is a reflection of that. I've handled cases where, you have kids that are 15, 16 getting charged as adults. Obviously, this is one of them, and you're faced with that problem of where exactly they're housed, how exactly the charges are going to sort of develop, and it's a very tricky situation when you're dealing with somebody that young. And I certainly understand his attorney's point of view, because obviously she's trying to advocate for her client, and she's doing a very good job of it. But I also do understand, and I'm totally not surprised by the judge's ruling, based upon the facts of this case.
Yeah, Lance LaRusso, this is always a difficult part of our system of justice when we have underage killers. Here, though, we're talking about a mass murderer accused of doing it, obviously. I haven't seen the video. The jury hasn't ruled yet. But your thoughts about how our system deals with 15-year-olds?
I think one of the things that people are overlooking in this, they just have this idea of this 15-year-old just being brought in the front door of the prison and put anywhere. There's a classification system that's put in place in American prisons. They go through everything from a screening of medical, psychological needs. Also, they look at risk factors. They look at the risk factors to the other inmates, risk factors to the specific inmate. So wherever he is housed, he is in an environment that will cater to his unique needs. In a very real sense, he is just like any other adult inmate who is vulnerable because of a medical condition or a psychological condition. So I think they probably can look out for him better and protect the public and the other inmates there better in that facility. Plus, as they said, an escape is a real concern from a juvenile facility. It's much harder in an adult jail.
Teresa, your thoughts about 15-year-old accused mass murderers, and what do we do with them before trial?
It's always a difficult question, and I have to agree with my co-analyst, but it's difficult. But based on the severity of the crime, I think that the county jail is equipped to handle him being there. He's entitled to medical and mental health treatment while he's there. I don't know about the whole argument about school, obviously, considering this was a mass murder at a school shooting. But I definitely think that the county jail, and I believe, if I'm not mistaken, I heard that there's an actual separate area in there within that he can, go to. So I think that kind of, meets all the criteria to keep the public safe, to keep him safe, and allow him to have mental and medical help if he needs so. Yeah. So I'm completely fine with the county jail.
Yeah, and I agree with the judge. Made a great point about, okay, you've got other juveniles, you want to keep them safe as well. He's a potential danger there. We know the age of the alleged victims. They were all kids. They were kids. All right. Think Tank staying with us. Still ahead. On the docket tonight, in Statesboro, Georgia, Marcus Wilson accused of shooting and killing a 17-year-old girl while driving down the highway. Wilson claims self-defense. We take a closer look. Plus, Ghislaine Maxwell's attorneys have spent a lot of time trying to separate Maxwell from billionaire sex offender Jeffrey Epstein. But photos show the couple seem to be very close and intimate. Tonight's 13th Juror question: what exactly was the nature of the relationship between Ghislaine Maxwell and Jeffrey Epstein? Go to our Facebook pages and let us know. On the docket tonight, the case of Marcus Wilson, accused of murdering a 17-year-old girl. Julie Janae has the story.
And I just want him home. I just want him home. He doesn't deserve to be in there.
21-year-old William Marcus Wilson has been in a Georgia jail since mid-June. He faces charges of felony murder and aggravated assault for the shooting death of a teenager, Haley Hutchinson. His family doesn't deny that he pulled the trigger, but his sister, Chelsea Burnett, says there's more the system should consider.
Mark is a gentle giant. He is a big old teddy bear. He's willing to cut his own just so someone else can have an opportunity. That is who he is. That's who we've been raised to be, and that's who he truly is. He doesn't have a hateful bone in his body.
She says her brother feared for his life when he opened fire on a truck of white teens the morning of June 14th. The car's driver was allegedly trying to run Wilson's car off the road, while others yelled racist slurs, according to his sister.
He had a right to stand his ground. He felt like his life was threatened, and I 100% believe that.
Detective Travis Cruen said Wilson's girlfriend was in the car with him at the time.
Wilson got his gun to show them, you don't do that, is what she stated. And she saw him shoot at the ground. She told him, don't do that.
Cruen said the fatal bullet from Wilson's gun went through the back window of the truck where Hutchinson was seated. The detective also said a beer can from the truck was found on the ground near shell casings.
Police later found a beer can on the roadway.
Yes.
And that beer can matched the beers that they were drinking.
Same type. Nobody can state that they saw anybody throw anything out the window.
According to the detective, the teen said they were drinking the night of the encounter, but no breathalyzers were administered. The truck's driver, Mason Glisson, testified he did not hear any trash talking from his passengers directed at Wilson.
Did you at any time swerve into the other lane? Is there any reason that did you have any anger?
One of the other passengers, Luke Conley, was later charged with a misdemeanor for obstruction. Police say he changed his story after initially telling officers he stayed inside the truck before the shooting. He later admitted he interacted with Wilson through an open window. Here's how Conley responded to questions from the defense.
She yelled racial slurs out of the window to the car that was beside the truck. Mr. Conley, did you throw anything at the Ford Fusion?
It's a case drawing attention to the small town of Statesboro, Georgia, and bringing scrutiny from civil rights groups over who stand your ground laws protect.
If he were white and his skin showed that he was fully white, he would not have ever been put in handcuffs. At the moment he said he was standing his ground, it would have been, we're going to do further investigation, and it would have never been where it is now.
According to his family, the shouting of racial slurs began after he left this Taco Bell drive-thru with his girlfriend, who is white.
When you have a car full of young white men in South Georgia calling your girlfriend an N-word lover and trying to literally run you off the road and is hanging out of the car shooting all kinds of words and explicatives, you can't really tell what's next.
In a police press conference captured by WSAV, Haley's family begged the public for information.
Our state, our counties need this message right here more than anything. There can be mercy, there can be forgiveness, but justice, it has to be served.
I want to show you some photos that we have, some evidence photos of what was found inside the truck where Haley was shot and killed. Here's the actual truck. And apparently there's some photos that show alcohol and some empty coolers inside the truck. So the question is, what is the defense going to have to establish here during the course of this trial to demonstrate that this was a justified homicide, self-defense? We've been talking a lot about self-defense recently here on Court TV. Let's bring back in our think tank, Lance LaRusso. You practice in Georgia. Yelling racial slurs is the allegation, throwing a can of beer, attempting to swerve and run them off the road. How does the defense get from where they are now to establishing self-defense here?
Well, the first thing we have to remember in Georgia, you have the stand your ground law also came with an opportunity for an immunity hearing. So all of these issues that are being brought up by the defense will be heard at a separate hearing if they move for it prior to a jury trial. So there'll be an opportunity to sort this out. But the issue of self-defense is, did the person using force act as a reasonable person? And the justification burden is always on that person who pulls the trigger. So when he left the scene, there's two questions I have here, but when he left the scene, did he go to a position of safety and call 911, or did he just leave? Well, we know it's the latter. He didn't turn himself in until 3 days later. Second, we heard that there was a bullet hole in a back window. So one of the questions that's going to come up here is, what was the trajectory of the bullet such that there would be a reasonable argument that he was using deadly force to protect himself? And if he's using deadly force at the vehicle to stop the vehicle, that's going to become an issue as to the relative position of the car to him at the time he shot. So his own actions, I think, are what's causing a concern for this being a stand your ground or justifiable shooting.
I'm going to have to agree with Lance on that. I think this is a really, as you know, stand your ground cases are very fact intensive. And I think just the yelling of slurs and, possibly, trying to run him off the road, I don't think that's enough for him to be able to claim stand your ground. And, I've been involved in a high profile stand your ground case. And these cases are difficult, but this one, I really don't think the defense has what it needs to prevail on this one, just based off of what I've heard. Now, if maybe there were possibly bullet holes in that particular car or, side swiping of the vehicle, even that would be a stretch. I think he'd have a better argument, but I think this is a really tough case for the defense.
I don't know. I'm actually going to have to really disagree with that one. I mean, if he is perceiving that there is a grave bodily threat, that he could suffer death even by them trying to run him off the road, I think that alone could actually do that for the defense in this case. Now, obviously, there's, conflicts in the testimony between the different witnesses here, but if the defense can show that they were actually trying to run him off the road, he has no duty to retreat whatsoever, and I think that they could actually successfully win that immunity motion hearing.
Yeah, the question is really going to come up to, and Georgia law uses this all over the use of deadly force and the defense statutes, reasonable belief. And that's why the immunity statute, the immunity hearing is going to be key. But if this comes down to a jury trial, a jury is going to have to decide whether whatever belief he had was reasonable at the time under those circumstances.
Teresa, what do you...
Honestly, I think that...
I want to throw something at Teresa real quick about the one passenger in that vehicle who's taking the fifth. Your thoughts about that and what that means to the prosecution's case and to the defense case?
I mean, I think it means that he didn't want to answer the question, but he knew the answer to those questions were going to be hurtful to him, obviously. But obviously, once you plead the fifth, I mean, there's really nothing more you can do with that. But I'm going to have to go back. I think, even the running off of the road, I mean, you can speed up. I mean, again, these are fact-intensive cases. Like, you can get out of, if you see they're trying to run you off the road, you can speed up further down the road or to try to get away and go to a place of safety. So I really think that, I don't know, it's a weak case for the defense. I'm not saying it's all the way, weak, but I think it is pretty weak based on what we have.
All right, that bell keeps going off. We're out of time. Let me take a look at what's happening with this case. And right now, Georgia versus William Marcus Wilson, no trial date has been set. There's some litigating that needs to take place. There are some issues involving motions and the judge, so we'll keep our eye on it for you folks and let you know what happened. When we come back, time to hear from you, our 13th juror, and it's all about what's happening in New York, the case against former Epstein confidant, whatever that means. I use the word all the time. I really don't know what it means, though, folks. I'm talking about Ghislaine Maxwell. What exactly was the nature of her relationship with Jeffrey Epstein, and how important is that going to be in her trial? Your verdict next. Oh, man. Yeah, I'm showing you the photos again, folks. This is actual evidence from the case against Ghislaine Maxwell. There she is rubbing the feet of billionaire sex offender Jeffrey Epstein. Oh, the humanity. Anyhow, part of the defense is trying to, distance herself from Epstein because everyone kind of knows who Epstein is and what he's about. But the question is, the jury's seeing all these photos of them together. And my question to you was, what exactly was the nature of their relationship? Because that could be the key, or really is the key to the trial of Ghislaine Maxwell. We begin with our 13th juror comment of the day, Suzanne, who says she clearly was in love with him, worshipped him, and would do whatever he wanted to please him. A twisted, sick love. Michael Bixon, do you agree? Was she just infatuated with him?
I mean, it's entirely possible, but I'll tell you what, that would actually be a better scenario, I think, for the defense than if the prosecution is able to show that, she had some type of financial incentive or that she was reaping the profits or something like that. So I think for the defense, it's actually better that she was in love with him or something like that.
He was just charming her. Oh.
Possibly.
All right, Sal tonight. She was as much a victim as the others. It's sad that they put her on trial instead of getting her the help that she needs. Teresa Jean-Pierre Coy, is there any chance that the jury sees her as one of his victims?
I don't think so. I think she was a little bit too old to be one of his victims to begin with. I mean, based on the charges that he has. But I think that they had a romantic relationship, and I agree with the first 13th juror that she loved him. She liked him. I mean, these pictures are, if you're rubbing a man's feet at that point, we've got to be together because there's no other way.
Harper, predator and enabler. Lance, let me ask you something. Are you surprised that there's been no deal by Maxwell to just name some names and give them over to the Fed? Isn't that what the Feds always do? They just want you to kind of flip and give them other people to go after?
In a way, I was surprised to start with, but when she was hiding out to the extent and thought that nobody would ever knock on her door to get her, I think clearly she indicated she's not going to cooperate with them. The prosecution's clearly trying to show her as a co-conspirator, a defensive coercion, that she was overwhelmed with some sort of duress, or just even that he just had total control over, is not going to work here. The bottom line, the acts that they committed were so heinous, and the testimony that's come out indicates such an intent on her part to overwhelm these victims and to gain their trust so that he could perpetrate these horrible acts and sex trafficking. It's easier for Epstein to have committed this crime with a facilitator. And that's essentially what the prosecution is trying to say, is that she's not only a co-conspirator, she was a tool that he used to commit the crime. And she never stood up and never did anything, despite probably hundreds of opportunities to stop it.
Lindsay tonight, he groomed her to be what he wanted and for what he needed. Michael Bixon, do you think she needs to testify?
I don't think so. I think that the defense already has plenty of witnesses that I know they're going to bring forth. I think it's too risky a move for them to put her up. I think they're going to instead just rely on the other witnesses, and I think it's a much safer bet.
Teresa, 35 witnesses on the list, but the court has sealed it. What are they hiding from us?
I don't know. Maybe there's some surprise special guests that are coming out. You know how the feds do. It's usually they wait to the very last minute to kind of get you everything. At some point, that list is going to be revealed, and I am looking forward to see who these 35 witnesses are.
All right, Teresa Jean-Pierre Coy, Lance LaRusso, Michael Bixon, awesome. Great to see you. Thanks so much for your help, your insight, your expertise. We'll see you again really soon. When we come back, folks, the Delphi murders, Abby and Libby, two 14-year-old girls. This is a case that seemingly should be solved. The killer is on video, but no one's been arrested. There's been some developments in all of this. A statement released today by the Indiana State Police. We'll take a look at that with our own investigators when we come back. In Hennepin County, Minnesota, former officer Kim Potter on trial for manslaughter after shooting and killing Dante Wright during a traffic stop. Testimony continuing in the prosecution's case as the jury tries to figure out if the shooting was an accident, a crime, or a justified use of deadly force. We are live with the latest.
New motions from the prosecution hope to undercut the testimony of one of their own witnesses. Former Brooklyn Center police officer Michael Johnson told the jury that Kim Potter would have been justified in using deadly force in the shooting of Dante Wright.